What would be the challenge there when it comes to the car? The watch, definitely, I agree. But what about the car? The fact that he uses it to earn a living. Okay, so you're saying it doesn't matter. It doesn't matter. It can. The business assets are his assets, so all of it can be used. Okay, fair point. Good. Anyone else? Okay. All right, so that's also true, because it's considered a car, maybe because we're told he uses it for business, it could be considered tools of the trade, right? Tools of the trade, so that's why you're saying, as a creditor, you could try, but you might hit with a bit of a challenge. Yeah, simple, thank you. Yes, go ahead. Well done. Yeah, so as long as you can prove it's not essential, you might be able to still seize it. Good point. Anyone else? Anything else? We've covered it all, have we? Bankruptcy, at least if bankruptcy will give, as a creditor, access to future income, right? Access to future income, because it's 170,000. So with what's available to him to be sold, it's not going to cover it. But a bankruptcy definitely seems more feasible because of the long-term rights that the creditor would have over Norlook and his earning capacity. Okay? Good. Okay, so what I have here, I'm just going to ensure that you've covered the main points. I've got that some options available to the creditor are bankruptcy and, an order for sale. In relation to bankruptcy, the property of the bankrupt vests with the official assignee. This includes provisions of the shop, other than what could be considered the tools of the trade. Okay, so the car, the watch, and the items in his house which belong to him. Okay. Other than the tools of the trade are necessary for the basic domestic needs. So that includes the money in the bank account. The HDB house and the shop cannot be seized because they do not belong to him. Okay. As for the order for sale, the same sorts of items may or may not be seized. However, bankruptcy is much wider in the sense that it covers items such as salaries or monies that the bankrupt may subsequently receive. The other thing to bear in mind as a creditor, you've got to weigh up the cost of pursuing a bankruptcy and the cost of pursuing an order for seizure and sale, right, the OSS. Bankruptcy is more expensive, it can also be time consuming. Even though you're in there for the long haul, you might not recoup everything you're owed for a number of years, right, so it could be considered time consuming. Okay, so the creditor and the lawyer may have to weigh up and balance the pros and cons of the various options. Okay? Good. Anything we may have missed? We're generally okay with bankruptcy and order for seizure and sale, probably the best ways to go about trying to recoup that debt. Okay. Even if after all the legal avenues for redress have been exhausted, so imagine every avenue that exists has been attempted, even after everything has been attempted, assume that you've not been fully repaid as a creditor. Is there anything else that you can do? Absolutely, spot on. If you've exhausted every legal avenue available as a creditor to recoup back your debt, the reality is you might not be able to recoup back everything, right? So there might be nothing else you can do. That's the harsh truth. Isa? As in which one's there? As in there's no legal avenue that can open, or true, as in you might have to just write it off as bad debt there, right? Yeah, you're absolutely right. Right? Bad debt, right? Just a tough luck situation. Queen? Okay. Okay, but even so in relation to this question though, so as a creditor, you would just advise, before you lend out money to anyone, just do your own due diligence, right? Do your own credit checks. Yeah, fair point. Good. All right, so is there anything that could be done earlier? So following on from the credit checks, right, that extra due diligence. Anything else that you can do as a creditor to minimize your risk?
Like they can access his credit worthiness.
Credit ratings?
Yeah, before loaning him the money. Or
Okay, it's
like,
true. You can do your checks, ask for a credit rating before you lend out money, right? So that you're trying to reduce the risks of you not getting paid. Yes.
Can you engage in like early intervention, like communicate if you see the debtor in financial distress?
As in the debtor?
Yeah, like the one that owes you the money.
Okay, yeah, bad point. Okay, good. That would be one way to minimize your risk, that you're fully informed. Anyone else? Come, keep your hands raised, fellas. Okay, Johnny. You what, really? As in, so you ask your money back within a shorter period of time? Yeah, that would help reduce your risk because you're getting back paid faster. Yeah, Johnny, that's right. Go ahead, David. Well done. So some sort of collateral, right? Take some sort of collateral before you lend out money. Absolutely. Yes?
The lenders can monitor the business so that like if you're accidentally financial.
Well done. Okay, so just keeping track of the business, right? So if you can foresee any problems happening, any bottlenecks, you can intervene a lot faster than just not getting paid, right, when you're meant to. Yes, go ahead.
Appraisers can also protect against borrower documents that purchasing of insurance, so there's straight credit insurance as well as loan default.
Well done. Absolutely, that's a given. Insurance, right? Before you lend out money, make sure you have an insurance or some sort of safety net in place in the event that you're not paid, right? That you have insurance in place so that you're not literally out of pocket. Well done. Nuri? Oh, you did? Okay. Thought you did. No worries. Thank you, Nuri. Okay. Absolutely, it's true. A bankruptcy. If you're going to make Norlock a bankrupt as a creditor, you apply to the courts to have Norlock be declared a bankrupt. It's true. You're not going to get paid your money immediately. It's 170,000, right? After all, it could take a number of years. It could take 10 years, right? Because again, Norlock still needs to live. So even though he's still earning money, he still needs to live. So what he can pay you might be very little, might be a few $100s a month. So it could take a long time. So when the question's asking, if all the avenues have been exhausted, meaning you've tried everything. So you've tried bankruptcy, but even then, you haven't been able to recoup back everything. Yeah, correct. But you still haven't been able to recoup back everything. That's what the question's asking. Okay? Good. Okay, so what I have here is, yes, you could have gotten trade credit insurance. You could have taken some security, some collateral. So it's great that you guys mentioned it. Taking a guarantee from someone else who's creditworthy. There are also things available in the market such as account receivables to factors, and these factors can be banks or credit swaps. But again, it's important as business students to know from the outset that it's always good to have measures in place in relation to your risk management, okay? So in business, always remember there's going to be risk. You might not always get back what you put in, and in the case of not being paid on time, always take out insurance. There are insurance products available that help reduce that risk. Okay, so the next question, Dee's asking, what if the facts were the same as stated in the first paragraph, but Norlock is in a partnership with somebody called Slack-Car? Can they go after one partner instead of the other? What do we think? Yeah? Absolutely. Well done, it's true. There's an existing partnership agreement that might determine the liability of the partners, but by virtue of being a partnership, you would certainly be able to go after one partner and not the other, and if you successfully sue one partner, that partner might be due to recontribute the one that didn't pay, he'll have to recontribute back to the partner that's had to pay. That's the nature of the partnership. We've got other hands that were raised. I want to ensure that anyone else have anything else to add? So yes, partnership means, you can go after one and not the other, right? And the one that's had to pay, partners are all liable, but the one that wasn't sued and didn't have to pay might have to reimburse the other partner. Right, what about if Norlook was running a company and Slackcar was a fellow shareholder and director, what then? Does that change anything? Right?
Slacko you don't have to do that because it's not part of the IT and the company are separate.
Well done. Absolutely. A company is a separate legal entity. Okay? Partners, remember, partners don't have a separate legal entity. Partnerships and their partners are the same, right? Whereas a company, indeed, is a separate legal entity. So, since a company is a separate legal entity, generally only the assets in the company can be seized. So therefore only the provision shop or things in the shop can be seized. Okay? What if the facts were the same, but Norlook and Slackcar were carrying on as a limited liability partnership? Then the things change? Does liability change if they're an LLP? Does anything change? Kayla, keep your hand raised. Anyone else? Yes, Janelle, thank you. Well done, absolutely. So LLP in law is treated the same as a company, right? It's a separate legal entity, right? So it'd be much the same in relation to how it's a company. And again, if it was if it was a limited partnership, then you'd only be able to sue in terms of the agreed contribution, whatever the partner's agreed contribution is as a limited partner. That's what will change. So I think that's the last question there regarding a limited partnership. So remember, a limited partner, you can only sue them based on their agreed contribution. Okay, so that's the key difference there. Okay, anyone have anything else to add for this question? Anything we may have missed? Any other observations or points to add? Yes?
May I ask, right, if there's a bankrupt situation,
Yeah?
will the bankrupt person have to pay as long as he's earning income until all the liability is fully paid to the creditor?
Correct.
I see.
So as a bankrupt, as long as you're earning income, however much you're earning doesn't really matter. Whatever it is that the court just deems as reasonable for you to be giving back to your creditors, it could just be $5 a month, based on your family circumstances. If you're earning an income, by right, you have to pay back your creditors. But the minute you're not earning an income, the minute you're out of a job, then by right, there's nothing, that bankruptcy procedure stops. Because you have to be earning in order to give to your creditors. If you're not earning, you can't give to your creditors.
Right.
So your circumstances can change, and then you appeal to the court to say, I can't pay my creditors. Right? I don't have a job, or I'm in between jobs. So the next 1-2 months, I'm not going to be able to pay anything. So it's not meant to be a death penalty. It's meant to help you pay your creditors, not bring you to your knees.
Right. So the creditor will eventually get back his money, just taking a very long period of time.
Correct. It could just take a very long time.
I see. Thank you.
Okay, you're welcome. Okay, anyone else? Yes? Well done. Absolutely. So in a partnership, it has to be the partner's wrongdoing. Absolutely. You would. The partner will be liable for their own wrongdoing. Other partners will not be liable. Yeah? Good. Thank you, Kayla, for adding that. So just to show you, trade credit insurance is available. Okay? So in instances where you, as a creditor, you have lent money and you want to be sure that you're paid on time, or you want to ensure you get your money back, okay? This can help. Getting insurance similar to this, and there's many that exist in the market. Many service providers provide them, okay? It just helps you to reduce the risk of non-payment. Okay, so these are the things to bear in mind. And also, getting credit checks. So, before you lend out money, obtain credit ratings from the people that you're lending money to. Lots of agencies and tools exist nowadays to assess an individual or a business's credit ratings. Okay? It's another way that you can mitigate your risk as a creditor. Okay? And then mentioned factoring. So in finance, this concept of factoring exists, where you can sell account receivables at a discount to banks. Usually, banks are usually factors. So this is another way that your risk can be reduced. Okay? Cool. All right. So that's question 1. Unless anybody had anything else to add that we haven't yet mentioned, or want to add an observation. If not, we move on to question 2. Yes.
For part G, I think it also matters that Mr. Tan has not been actively managing that.
Okay, fair point. Absolutely. Has to make clear what type of a role he had within the within the partnership. You're absolutely right. That will also determine liability. Absolutely. Well done. Okay, so excuse me. Question 2. So we've got Tom, Dick, and Harry, and we're told that Tom, Dick, and Harry are in an ordinary partnership. Okay, and that ordinary partnership is an accountancy firm. So we're told they have equal shares and have contributed equally to the capital. Okay, so now a series of situations happen, okay, and we're told to advise Dick and Harry regarding them. So Tom has been quite busy. So what's the first thing that's happened to him? So we're told that Tom leaves home one morning by car to meet Joy, who happens to be a client of the firm. On the way, he knocks down Hope. Is the firm liable? Please start this side of the room. Go ahead.
The firm is liable because Tom is on his way to meet a client, which is undertaken in the ordinary course of the partnership's business.
Okay, brilliant. So the fact that we're told that Tom, he's gone to meet Joy, who happens to be a client, right? So if she happens to be a client of the accountancy firm, absolutely, the fact that he's in the car going to see her means it's in the course of partnership business. In the course. So some wrongful act has happened whilst doing partnership business, which clearly that we can argue it has been, then the partnership could be liable. Absolutely. Well done. Anyone else have another take on that? So is that it? Is that the only way to look at it? Is the partnership liable, full stop?
But then if like Tom met Joy for like personal matter, like then the phone wouldn't be liable.
Okay, well done. That's the twist, right? So if you wanted to add a bit of however to it, because okay, we're told that Joy is a client. But what if he's going to meet her not for client business per se, although she is a client, but he's not actually going. She's a client, she's now become a friend, now she's in hospital, and you're just going to go see Joy as a friend, in the capacity as a friend, then that would not be clearly in the partnership business, in the course of partnership business. So that would change liability. That could change liability from the partnership not being liable. And then the other thing is, we're told he leaves from home. The partnership could argue, we never asked you to go meet Joy, or go check on her, or go visit her. That wasn't an instruction from the rest of the partners. You decided, you left from home. Had you left from the office to see her, could argue it's in the course of partnership business, but you've left from home. So, you could argue, actually the partnership's not liable. Okay? Anyone else have a different take or anything to add? Yes?
I have a question. Then how do you prove whether it is for business reason or for normal?
Well, it would be up to the partnership to prove. Was Tom acting as a partner in the business? If he was acting as a partner for that particular meeting, that particular meetup, was it for the benefit of the partnership? It would be up to the partnership to prove it wasn't, if they don't want to be liable. Okay? Then the other thing, which I don't know anyone thought about, was we're told he knocks down Hope. But what if Hope ran out in front of him? Would the partnership be liable? What if Hope is the one that was running out? She was distracted, she was on her phone, she walked out in front of him. Then what? Is the partnership liable? See? These are the things to consider. Like, We equip you with the principles. So we've hopefully equipped you with the principles of partners and partnerships and liability. Your job is to apply those principles to the scenario. You can infer. You can read between the lines. Nothing's stopping you. In fact, if you were representing the partners or the partnership, and or one of you is representing Hope, the one that's been knocked down, you would argue things very differently because you would see things very differently. Do you see? It depends on whose shoes you're in. Your facts changed according to that, don't they? Right? What happened hasn't changed, but the reason why they happened can change. That's based on your application. Right? So your interpretation can change. Okay? Anyone else? Did anyone think of anything different? Okay? Yes. Yeah. You can absolutely. So if you're in your answer, you've had a discussion about implied or apparent authority. Brilliant. Absolutely.
But if we actually left out like implied authority, I feel you get left out.
No. Absolutely not. Absolutely not. Just as long as you've answered the question. So the question's asking you, is the firm liable? So as long as you've done your best to argue whether you think the firm is liable or whether you think the firm is not liable. If you think the firm is liable, explain why. If you don't think the firm should be liable, equally correct, explain why. So as groups, or as individuals when you're writing out your tutorial answers, you could have very different answers to the rest of your classmates. It's perfectly fine. In fact, we encourage you to have different answers. Just be able to explain why. Why is the firm liable? Give an explanation. Or if you feel no, the firm's not going to be liable, give an explanation. As long as you explain. Because you get marks for your explanation. You don't get marks for the right answer. There isn't a right answer. Whether you're Hope or whether you're Dick and Harry, you will have different answers you want to arrive at. Right? Depending on who you're acting for, you would want a different answer to be correct. So apply the concepts and principles based on who it is you're representing. Here, generally, you've just been asked, is the firm liable? So you could be yes, and that's correct. And it could be no, and equally correct. Right? Anyone else? Yes. You can definitely, yes, you could. That's one way to approach it. I mean, a good answer would be the firm would be liable because of X, Y, and Z reasons. However, the firm might not be liable for X, Y, and Z reasons. A good answer would be however, or on the other hand, and give the other explanation. Right? Answers that are balanced definitely show much more analysis, much more application, and you gain more marks. Okay? Rather than, is the firm liable? Yes. Full stop. Now that I wouldn't be able to give you analysis marks for that, right? Okay? Okay, what's the next part saying? Will your answer be the same if they were running a company and all three of them were directors or it was an LP? So would liability change depending on the company structure? What do we think? Does liability change? Because we're told this is a partnership. But what if it's a company and he knocked down somebody, then what? Does it change anything? What do we think? Well, if it's a company and it's a company car he's in, company's still going to be liable, right? Because the employee has committed a legal wrong in the course of employment, right? So they could still be liable. Do you tell me?
I think it depends on whether the company is able to prove that wrong, whether not in the course of business.
Yes, correct. It's all about that legal wrong. Did it happen whilst at work? Or did it not happen at work? Because if it didn't happen whilst working in the course of employment, in the course of partnership business, the company would not be liable. But if it happened whilst at work, by virtue of it happened during office hours, right? Under the office watch, the company could jointly be held liable. Okay, good. All right. So, unless there's any other thing that we didn't yet cover for the first part that you want to raise that hasn't yet been discussed, we'll move on to the second thing that Tom's been doing. So you can see Tom's been quite busy. The second thing Tom's got up to. So we're told that Tom orders some stationery. He orders it in the name of the partnership from a sole proprietor who knows Tom is a partner in the firm. When the other two partners find out, they do not think the partnership requires the stationery because that stationery is quite expensive. Okay? And they don't want to pay for it. The other partners don't want to pay for it. They feel it's too expensive. He shouldn't have actually ordered it. They don't actually need it. So, does the partnership have to pay for the stationery that Tom has bought?
Yes, it's bought under the name of the partnership form. And also it's
Okay. Well done, Suzanne, exactly. The fact that Tom has the authority, right, the apparent authority, because he's a partner. Partners can buy things in the name of the partnership business, right? Especially when they're all equal share, equal contributions, we're told. He surely can buy things that the partnership needs, okay? So actually, even though the other partners are unhappy that they're having to pay out for the stationery, as we kind of said, actually, tough luck, no choice. Stationery is being bought, the partnership has to pay for it, right? Because Tom, by being a partner, has bought it for the partnership. So by virtue of that authority, that apparent authority, the partnership would have to pay. Isa?
Well, they are contractually obligated to pay for it.
Yeah, absolutely. Because it's been bought, right? The contract has been formed, the partner has bought the stationery, the firm would have to pay. Absolutely, the contract's already there. Okay, would your answer be any different regarding the company? If it was a company and there were directors, or it was an LLP, would it be any different? Would the company still have to pay? If a director bought things, would a company have to pay? Yeah, absolutely. Right, depending on the type of authority that can be established, you might find that they would actually have to pay as well. So what I've got here is, every partner is an agent of the firm and has certain implied or usual authorities to act on behalf of the partnership. Buying goods usually needed by the firm would fall within this authority, and on the fact, since the goods are just, we're told, slightly more expensive, quite likely the purchase is within the partner's usual authority, and therefore the rest of the partners would have to pay. Okay? Generally, the answer would have been the same even if it was a company, as directors too have things such as actual implied authority. Right? This idea of authority, fiduciary duty, all of that stuff applies to whether you're a partner in a partnership or whether you're a director in a company. Yeah.
Let's say the goods that Tom purchased were significantly more expensive
Yeah.
and reasonably expensive.
Yeah.
And the partnership back out of the goods, proving that Tom is totally like a fiduciary.
Absolutely. So that goes back to absolutely valid point. So because we're told it's a partnership, we're not told the actual mechanics. We're not told about the partnership agreement. We're not told exactly maybe the profit share arrangement. We're not told the actual nitty gritty. But if in fact in the partnership agreement, the partners agree that you can buy things for the partnership, but if it's over a certain amount of money, you have to get the approval of the other partners. If that was what was agreed, and Tom didn't follow that, absolutely the other partners have every right to not pay. And to just get Tom to pay, it comes out of Tom's salary, not the partnership. That could be an agreement that they have, absolutely. So if in your answer you presume that this is the agreement, and therefore Tom will have to pay himself, that's perfectly a legitimate answer. Yes. Yeah. So here the partnership might pay out, because they have to, because Tom bought the stationery for the partnership, but if by right they might charge Tom for it internally. They might just ask him to pay back the partnership. Yeah, that could be an internal agreement that they have with each other, absolutely. Okay? Now, okay, so what's the last thing Tom's been up to? Okay, we're now told that Tom has given tax advice on the side, we're told. And we're told he's not disclosed it to the other partners, and we're told he's made a profit. Other partners find out. Must Tom account for those profits? What do we think? Michael, go first.
The accountancy firm also provides like tax advice when there's a breach of fiduciary
Okay, so you're absolutely right. So tax, accountancy, I'm not very well versed in that area, but I'm presuming for the accountants amongst us, as accountants, do you always have to be knowledgeable of tax? Does tax play a huge part of your role as an accountant? What's the general consensus? Is it one and the same? Can you be an accountant and never dabble in tax? Can that happen? I don't know. I'm honestly don't know. But I would presume if you're an accountancy firm, your job is to file returns, right? And to do the bulk of what accountants do. So although tax, you might have to be well versed in tax, probably not the core of your work. Maybe a little bit of an overlap. So indeed, if the firm does do tax work, and Tom has taken on work and not told the rest of his partners, it could be definitely a breach of fiduciary duty. Okay? But even if the accountancy firm doesn't do tax work as a big thing right now, doesn't mean that in the future it won't want to. But even in saying that, as a partner, in a partnership, you do have a fiduciary duty, right? Especially when you've made profit, right? When you've made profit and you haven't disclosed it, that in itself suggests something suspicious. Okay, so there could be some breach of fiduciary duty. Anyone else? Yeah?
If he got his side job
Yeah?
as a result of his role as a partner,
Yeah?
the accountancy firm, then he should.
Yeah, I agree, absolutely. If this opportunity only came about because of his role, because he's a partner in an accountancy firm, all the more there could be a breach. Yeah, absolutely. All the more there'll be a fiduciary breach because he hasn't disclosed it. Okay? So he probably does have to account for his profits. Would your answer be generally the same if they're running a company? If they were directors or an LP? What do we think? Does the same principle apply? That fiduciary duty, does it apply? Yeah, it does, right? Same principles apply. So, every partner must account to their firm for any benefit derived by him without the consent of the other partners. Okay? Generally speaking, a breach of a fiduciary duty, you cannot compete with the company, and these obligations are likely to be breached on the facts. Okay? So, Tom would have to account for those profits. Okay? If we assume the firm doesn't actually do any tax work, we still probably can't rule out that the firm will never want to do tax work, and hence there could have been a conflict of interest in that situation. So by right, he should have gotten the consent of the other partners. Okay, should have just informed them. Right? If the firm currently doesn't do tax work and he's been offered some tax work, he could just say, "Look, I've been offered some tax work. I'm just letting you know I'm going to do this piece of work, but it's on a personal basis." He could have informed them. If he had informed them, that's different. Then there's no breach. But he didn't inform them. Okay? And it's a partnership, so by right, it could be argued that there's been a breach. So again, yes, the answer would have been the same if it was a company or an LLP. However, bear in mind that a company bears criminal liability. A breach of a fiduciary duty when you're a director of a company bears criminal sanctions. That's the key difference there. In a partnership, no criminal sanctions, civil sanctions for breach. But in a company, by virtue of being a company, we're governed by the Companies Act. So there could be criminal penalties for breach. That's the only thing to bear in mind.
If the firm does not do tax work now,
Yeah,
how would that still be a breach of fiduciary duty?
because there's a possibility, even though they don't do tax work now, accountants and tax, although clearly they're a self-sufficient profession, they may dabble in tax. There may be some overlap in some areas of their work. So even though they don't do any tax work now, doesn't mean that they'll never do tax work. So it's still a plausible opportunity that he could be taking away from the partnership by taking on tax work and not declaring it. There's nothing wrong with him taking on tax work. Nothing wrong with if you're a partner to do your own thing, have a side gig, there's nothing wrong with that. But when you're in a partnership, you do need to declare things that could be a conflict of interest, or if not an existing conflict of interest, could potentially be a conflict. You still need to keep your partners informed. Because if you're not honest and transparent in a partnership, it defeats the purpose of the partnership. Okay, thank you, Sintong. Anyone else? Yes.
What if they choose like a completely different industry?
Then, Benjamin, probably not a conflict of interest. Because he's not taking a rice bowl away from the partnership. He's not taking anything away from the partnership because he's dabbling in a business that's got nothing to do with the business of the partnership. However, you still keep your partners informed, right, about what you're doing. Just keep it, that's the nice thing to do. Okay? Thank you, Benjamin. Anyone else? No? You sure? Yeah. All right, so moving on to the next question. Okay, we've got Wood's, well-known US chain selling organic products. We've got Arding and Ardong. We're told they visit America to open up Wood's in Singapore. So assuming that Wood's in principle is agreeable to granting them a franchise, assume that Arding and Ardong intend to contribute 500,000 to capital, and they intend to borrow another 500,000 from a bank. So first question is asking us, advise Arding and Ardong as to what sort of business they should set up. So given the facts, in knowing what we know about the 5 different business structures, what's the best business structure for Arding and Ardong in your opinion? Hold that thought, Lauren. I'll come back to you. Yeah, you want to go ahead first?
It was just like a company.
Okay.
Company because they are expecting to be getting 500,000 for their back. So
Yes.
it's better if it doesn't. They don't put their own personal assets in a vulnerable position.
Brilliant.
So that they're not a liability of the debts.
Brilliant. So being a separate legal entity, there's more protection. Yeah, absolutely. Thank you, Jordan. Anyone else? Lauren, you were going to say?
Yeah, private limited company because then their liability will be limited only by the shares.
Well done. So company as well. Good. So company, we're getting company. So Jordan and Lauren is a company. Anyone else thinking of another business structure that might be feasible? Yeah?
Maybe an LLP.
Well done. Absolutely. Because of the separate legal separate legal entity status. Wonderful. Absolutely, I agree. Company or an LLP probably be the best thing to do, right? Given the risk involved. Okay. So the next question saying that there's been a sale of some defective products. Singapore operations incur a liability of 2 million. What would Wood's level of exposure be to the liability? Anyone? Yes. Okay, so if they were, depending on a partnership or an LLP? Partnership, they would share it then. Brilliant. So partnership, they would share it. If they're a company, then what? Correct. Liabilities on the company, not them personally. Well done. Okay. So what if Woods decided to directly invest in Singapore on its own, sets up a branch? What would then the exposure of liability be?
The legal matters will directly attached to the parent company.
Okay, true, because it's a separate legal entity status. Good, because it's a separate legal entity, the directors and shareholders won't face personal liability. The director who actually committed the wrongdoing can be personally liable. Good. Well done. Okay, and the last one is about personal negligence. Okay, so if they set up a branch, they'd be liable for the whole 2 million. They're setting up a subsidiary. In this case, the subsidiary will be liable and only its assets may potentially be seized. Okay, but on the facts, only assets of Woods Incorporated can be seized and not that of its directors. So deciding what type of entity they set up will determine the liability and the risk that they take on board. Okay? Good. All right, so which takes us to, I think, the last question. Okay, if you're running a business, subject to the exceptions, it must be registered. What amounts to running a business? What are the relevant factors in deciding whether a person is running a business? Any ideas? So what are the factors that you care? Isa?
Constant revenue stream.
Okay, revenue stream, constant one. Thank you, Isa.
It depends on the intent, whether it's to derive monetary gains.
Okay, so when you're deriving monetary gain profits, that will also determine whether you're running a business. Well done. Anyone else? Yes, there you go.
High volume or high
Okay, high volume and high value. That will determine a business, okay? What factors do I have? You've covered the majority of them. I've got things like frequency of transaction, extent of transactions, whether capital is employed, whether you've got employees, whether you've got a business name, whether there's a chance of profit and risk. So those are some of the factors. Not exhaustive. Okay. If you're giving tuition, I think most of us in Singapore, students usually give tuition as an extra source of income. Do you need to register? What do we think?
No.
No? No, and then you're saying
No, because
no as well?
Yeah.
Okay, both of you gentlemen, would you want to go first and then Lisa? What do you think? Okay.
If you're doing like family friends,
Yes.
for example, like it's an isolated case, you wouldn't have to do that.
Like a one-off.
Multiple and you're sourcing for more.
That's right, absolutely. Again, if you are giving tuition and it's in your own name, right, you don't need to register. Lisa?
Like you're using your own name.
Correct. If you're using your own name, you're getting your fees paid to you by PayNow into your bank account, right, in your name, you don't need to register, especially if it's ad hoc. But if you're having to employ, rent space, employ teachers, employ tutors, then you probably want to register. But on an ad hoc basis, especially when you're using your name, you don't need to register, you're absolutely right. You also raised your hand, same thing, okay, brilliant, noted. All right, yes, go ahead, Noreen. As long as, I think there's a threshold. Over a certain amount, if you're gaining profit, earning income, you'd have to declare it. But by right, if you're making a profit in your own name, you don't need to pay tax when it's on an ad hoc basis. It's only when it's more substantial do you need to. Yeah?
But even if it's on an ad hoc basis, it wouldn't help you if you register it because
Yes, I mean, the only, registering is always recommended because it's protection, right? Protection not just for the business owner, but for people that you engage in your products and services. You should always try to register, okay? But when you're doing the ad hoc business in your own name, by right, there's no formality, and it's not an obligation to register, okay? All right, guys, thank you for today. That's what we needed to cover. We've overrun slightly, I apologize. But I shall see you on Saturday. Saturday morning, 9 a.m. I know, it's not